Hello friends, welcome back. In this video lesson, we shall talk about the pitfalls and roadblocks that the society may face during the process of recovery of dues from a defaulter. As you have seen in an earlier video, a defaulter is a member or occupier who fails to pay the dues of the society within 3 months from the date of service of bill or notice or due date of payment. The definition is very clear and the action proposed is also very clear, but we shall explore what are the roadblocks and the pitfalls that we are likely to face and what precautions must be taken. As all of you probably know by now, the recovery procedure of society dues has changed since the amendment of the MCS Act in 2019. Now, Section 101, which was very well known for recovery, no longer applies to housing societies, and instead a new section numbered 154B-29 has been introduced. As mentioned in an earlier video, society dues are treated as land revenue arrears, which means that the defaulter is not just owing money to the society, it is treated as if he has not paid the government the land revenues. And the government acts swiftly under the provisions of the Land Revenue Code 1966. Recovery is easier said than done, and there are some very common roadblocks which can often lead to delays or even rejection of the society's petition to the registrar. For example, if there is any disputed amount in the bill for which there has been some argument or discussion when it was included in the invoice. If the invoices have been sent and there has been no dispute about that, you can go ahead with the proceedings. The next thing is the billing should be accurate. There should not be any inaccuracies. Even simple additions and stuff like that can matter. The statement of account must be provided. You must give a detailed statement of account of the person against whom you are instituting these proceedings. And you cannot proceed under section 154B-29 in case any of these roadblocks are existing. If any of these are wrong, then the application will be rejected and the billed member can seek relief under section 91 of the MCS Act. We shall talk about this section later also. In order to succeed in your process of recovery, you need to plan, prepare, and perform. Make sure that you attach all extracts of the registrar approved copy of bylaws for charges and for interest rate on late payment. All the heads of billing should be as per the bylaws. Another important point is that you must also include a copy of the resolution or the bylaws where the billing cycle is mentioned. It could be monthly billing cycle, quarterly, or annual. In the case of our society, it is annual. Once the application of the society is received by the registrar, he or she will do the following duties. The registrar will hear the claim of the society. They will verify whether that claim is accurate, correct, make sure that there are no disputed or false claims, and in case there is any disputed or false claim or miscalculation, the registrar will immediately dismiss the application. The registrar is not authorized to hear any disputes. In case there is a dispute, the parties will have to go to the cooperative court of the district. Here is a summary of the main reasons for rejection by the registrar, and they are quite easy to avoid. First of all, the amount claimed should not be disputable. There are no false headings of accounts, and all the documentation which is supporting the claim of the society of dues should be complete. I've already talked about that in an earlier slide. As I mentioned earlier, all the headings of all the accounts must strictly be in accordance with the bylaws. In particular, bylaws 65, 66 and 67. Now, what happens about township maintenance charges? These are not part of 65, 66 and 67 bylaw. Therefore, do not include that in your claim which is sent to the registrar. Township maintenance charges are not mentioned in the bylaws, and there is a separate TMA agreement according to which the recovery of the TMA arrears is the responsibility of the Township Maintenance Authority or agency, not that of the society or the registrar. These will not be treated as land revenue arrears. Since the application is not correct, it can be rejected outright. Let us now do a brief and quick recap of the procedural steps. The first step is to serve a recovery notice to the flat owner who is the defaulter. Next, you can send 2 reminders at intervals of 2 weeks. Each time you must attach the account statement, and the initial recovery notice must have all the accompanying documents which have been listed earlier. Very briefly, you must describe each billing head separately, and the billing heads must be as per bylaws 65, 66 and 67. The next important thing is that without the billing heads being in order, the notice is void. And finally, attach the audit report of the auditor, which makes a statement or a list of all the debtors and the amount outstanding. Here is the list of documents which needs to accompany your notice. First of all, it is the account statement of the particular flat owner. Next, copies of the invoices that have been sent earlier. Also include the approved budget, which shows the breakup of charges and all the calculations. The next thing is to include copies of notices in all the reminders. Also include the audit report, which shows the list of defaulters. Next, include the general body resolution, which states that the general body approves the recovery through this route of invoking section 154B-29. Also include copy of the page of bylaws showing the rate of interest to be charged on late payment. And finally, also include the resolution or the bylaw which states clearly that our society is collecting the dues on an annual basis. Finally, there is one important point you should not miss, that the presence of the representative of the society, either from the managing committee or the office bearer who is representing the society, is required to be present when the hearing date is given. If either party is absent for 3 consecutive occasions, the deputy registrar can give an ex parte hearing or ruling. This applies both to the society as well as the defaulter. So friends, there is one important Bombay High Court judgment with regard to limitation. In India, we have a law on limitation, and this is the case of Versova Garden Cooperative Housing Society versus the Divisional Joint Registrar. If the claim of the society is for dues which are more than 3 years old, in that case, please remember that the society, if it has not recovered dues from the defaulting members for 3 years, then it will be difficult for the society to recover it under the MCS Act 1960. What can you do in the case of areas which are more than 3 years old? Well, the task is quite difficult, because then you will have to settle this dispute under section 91 and section 92 of the MCS Act, where the period of limitation is not restricted to 3 years. But then that is a long legal route. However, friends, if you do take recourse to going to court under section 91 and 92, Please remember that there are many roadblocks on the way, because this will be a full trial where all legal formalities of the regular suit, like recording of evidence, framing of issues, cross-examination, arguments, and all that will be applicable. And by the time it reaches the Supreme Court, it could be a generation old. So friends, what is the moral of the story? The moral of the story is that members must compel office bearers of the society to initiate recovery action within a period of 3 years, failing which the society might lose their right to recover the amounts that could have been recovered by the society otherwise. That is the cost of delay, and that is the cost of not initiating action in time. A stitch in time saves 9. Nothing could be closer to truth than in this case. So friends, that brings me to the end of this video. Here is a quick summary of the points that were discussed. In this video, we saw what are the procedures and what is the documentation required to act against defaulters. Next, we saw what are the pitfalls and roadblocks that can occur in our journey and what are the precautionary measures to be taken. And finally, we looked at the law of limitation and why it is necessary to stitch in time to save 9. So friends, thank you very much for your attention, and we shall meet once again in another lesson. And until then, bye bye and thank you.